Dear all, today we can take up one problem under labor law, which is with regard to the formation of the trade union by the police personnel. Here, in the problem, it has been given a group of policemen of Karnataka formed the group and applied for the registration of their group under the Trade Unions Act of 1926. These are the facts of the case, and further, the registrar of the trade unions refuses to register them under the Trade Unions Act of 1926. Here, whether the registrar is right in rejecting the proposal of the policemen to register their group under the Trade Union Act. So this is the problem. Here, how to solve this problem? Here, one thing I want to tell you that probably you know the police personnel, they are not meant for forming the trade unions, and they cannot join the any trade unions, except that they can form the unions for the purpose of recreational purpose, for the purpose of the religious purpose, for the purpose of social purpose. Likewise, they can form the groups. Such unions can be registered. But here, what is the question here? Whether the policemen, when they have formed the group, and whether they can be registered as a trade union under the Trade Unions Act of 1926. Here, what happens if they once they got registered under the Trade Unions Act, they will get all the what we call the rights which has been available under the Trade Unions Act. For example, strike and what we call other things. Here, what is the prominence is that they are the force. They are meant for the maintenance of the public order, and they have got the responsibility to maintain the public order, and they cannot deviate from such purpose. That's why under law there are certain restrictions has been imposed for the armed forces, including police. So let us go to the problem. How this problem has to be solved? Here I used to tell you that there is some one method is there, that is IRAC method, framing the issue and mentioning with regard to the rule of law or sections, and discussing all the things, that is issue, the provision of law under analysis, and discussing the what you call decided case laws of various high courts, and giving the judgment. So this is the format in order to what you call solve the problem. Here, first one is let us go to the issue. Here, issue part is very important. Here, you have to frame the issue with regard to any problem given under the facts of the case. Being a lawyer also, that is the thing. Here in judiciary, in what you call being a lawyer, with regard to any case, the issue is very important. What is the problem between the petitioner and the respondent, and what is the grievance of the petitioner? So when we know the facts of the case, we can easily frame the issue when we know the grievance of the petitioner, so or the plaintiff. Here, what happens? Here the issue can be formed like this: whether a group of policemen in Karnataka can validly register themselves as trade union under the Trade Unions Act of 1926. Here, you can form more than one issue. It's not necessary that you can form only one issue. there is no limit, but it is wise. You can frame one or two issues. Here, next issue is that whether the Registrar of Trade Unions was correct in refusing such registration. That means here on the facts of the case, the issue has been framed. Here, on the basis of that one only, your answer has to go. Here, and after framing the issue, you have to go. You have to go to the rule of law or the provision of law. What the law says with regard to this problem. Here, we have to go to the Article 19(1)(a), C and Article 33 of Constitution of India, which is much relevant with regard to the present problem. And you know that under Article 19(1)(a), 19(1)(a)(c), it has been given that you can form the any association. There's freedom to form the association. That sort of the fundamental right a citizen is having. But with regard to the forming of the trade union, what the Constitution of India says, whether it is a full-fledged fundamental right, means it is not the full-fledged fundamental right. That means here what you call the Constitution of India, which gives the what you call the right to frame the issue. But here what happens? Here this is 19(1)(c) that I wanted to write here. Here the Constitution of India, it provides, but it's not the full-fledged freedom. What I wanted to tell you that it's not the full-fledged freedom. Here that right it is having that is that there is some reasonable restrictions can be imposed on Article 19 subclass 1 subclass C of the Indian Constitution. So here, with regard to the forming of any kind of union or group, that whether the police forces can form this sort of the union or group, or whether they can register under the Trade Union Act. So that is the question here. Here, with regard to that one, there is one more article is there. That is Article 33 of the Constitution of India. What Article 33 of the Constitution of India says? Here, with regard to the Article 33 of the Constitution of India, it gives the power to the Parliament. The Parliament has got the power to restrict this armed forces to not to form the what you call the unions. So here that sort of power the Parliament is having. So what is the reason behind that one is here that under Article 33 of the Indian Constitution, which empowers the Parliament to amend the fundamental rights in their application to members of the armed forces, members of the organization charged with the maintaining of the public order. And here that is the main thing. That is they are in charge of the maintaining of the public order. And when they provided this sort of the rights to form the association, right to join the trade unions, then it will cause some what you call public disorder. There are chances that which may cause the public disorder. So this aspect we know. Here with regard to this one, the Parliament has passed the Police Forces Restriction of the Rights Act of 1966. That is applicable to the central forces. Police Forces Restriction of Rights Act of 1966. Likewise in Karnataka also, the Karnataka Police Act of 1963 is there. Likewise Police Incitement to Disaffection Act of 1922 is there. And these the certain acts are there. Here what we have to know, we have to mention these articles and we have to highlight the law, what the law will say. And this with regard to the Constitution of India and the Police Act, and with regard to the Trade Union Act, what the Trade Union Act will say. Here under section 2H, which says with regard to the what is meant by trade union? Here, trade union means any combination of persons formed primarily for the purpose of regulating relations between workmen and the employers, or workmen and the workmen, or employees and the employers. So this is the definition, and we think that this definition will not be applicable to the policemen here. So here under section 4, which provides for the registration of such trade unions, and here with regard to the relevant provisions which has been maintained under the Trade Union Act of 1926, the police personnel, they cannot ask for the registration of the unions under the Trade Union Act. Here there are certain judicial decisions are there. So, and we can take these judicial decisions as the precedent. In Kameshwar Prasad versus State of Bihar, the Supreme Court has held that government servants, including police personnel, do have certain fundamental rights, but these cannot be curtailed reasonably in the interest of public order and discipline of the force. But this is some what you call, it is a deviate from the present concept. But in the subsequent judgment, the Union of India versus H.C. Goyal, it has been said that public service in discipline forces like police must maintain discipline and cannot compromise operational efficiency. So this we can see, like in subsequent decision, State of MP versus Association of Criminal Courts, it has been held that the members of the discipline forces, that is the police forces or military forces like police, are not entitled to form trade unions. It has been given very clearly. It has been reported in the year 1970, page number 1660. So here the court held that members of the disciplined forces like police are not entitled to form trade unions because it would impair discipline and efficiency. And so this is the thing we have to appreciate. And here we have to explain all these things under the application level. So when we framed the issue, then we have first we have to frame the issue on the basis of the facts of the case. Then we have to highlight the provisions of the law, and thereafter we have to write the judicial decisions, and then we have to discuss all these things in the application part or analysis part. So here we have to discuss all these things in the analysis part, and in such a way that the conclusion also comes in this way only. So in application part or analysis part, every discussion we can make. Here this sort of the liberty will be provided here. That means the group of policemen applied for the registration of the trade union under the Trade Unions Act of 1926. This is the facts of the case. However, under section 3 of the Police Forces Restrictions of Rights Act of 1966, they cannot form the trade union. So why? Because of they have to maintain the discipline, and they cannot go on strike because which would affect the public order and safety. And the Register of Trade Unions is bound by this law and cannot allow such registration. So this is the thing we have to write. Likewise, in the end, we have to conclude. We have to give our the opinion with regard to the present case based on the facts of the case, on the issue, rule of law, and analysis. Here what we have to write: the Register of Trade Unions is correct in refusing to register the group of policemen as a trade union. Here this refusal is legally justified because the Police Forces Restriction Act, Rights Act of 1966 expressly prohibits the police personnel from forming the trade unions. So these things are there. So the Supreme Court has consistently held that members of the disciplined force like the police are subject to special restrictions in the interest of the public order and operational efficiency. By this time you know why the police personnel cannot form the what you call association for the purpose of registering themselves under the Trade Unions Act, but they can form the groups for other purpose. There is no bar. So therefore the registrar acted within the law, and the policeman cannot validly form a trade union under the Trade Unions Act of 1926. So this is the judgment. This is the concluding part. You have to write. You have to write very clearly. Most of the students, they will write just yes or no. They will not follow this method. So when you don't follow this method, you cannot get the answer. So that is a problem. If you write generally, the valuer could not able to come across what is the legal legal reasoning behind in answering the problem. So okay, this is the first problem which I am solving under the labor law. Let us go further in solving the labor law problems.